All rise. The Supreme Court of Guam is now in session. The Honorable Chief Justice Robert J. Torres presiding.
Halfway, good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRQ24-001, request of Lourdes A. Leon Guerrero y Magahagan Guahan relative to the duties of the Attorney General of Guam to the executive branch agencies. Appearing for petitioner Governor Leon Guerrero are attorneys Leslie Travis and Jeffrey Moots. Appearing for the Attorney General of Guam is Attorney General Douglas Moylan and Assistant Attorney General Nathan Tennyson. Appearing for joint amici curiae, Guam Memorial Hospital Authority, Guam Waterworks Authority, Guam Power Authority, and Port Authority of Guam are attorneys Jordan Paulun, Teresa Rojas, Marianne Wallachuk, and Jessica Toft. The panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, Associate Justice Catherine A. Merriman. Your Honor, attorneys Travis and Moots reserve 5 minutes.
You may proceed, Ms. Travis. And just to recap, the governor's total will be 33 minutes. You've reserved 5. Amici will have 10. The Attorney General will have 40 minutes. You may proceed.
Good morning, Mr. Chief Justice, Associate Justices Carbolito and Merriman. May it please the court. The Organic Act of Guam mandates that the Attorney General shall be the Chief Legal Officer of the government of Guam. Despite this requirement, approximately 3 months ago, Attorney General Doug Moylan withdrew legal representation from 22 executive branch agencies, including key line agencies, because he did not want to implement conflict screens between attorneys representing the agencies and attorneys investigating agency conduct. Executive branch agencies are the Attorney General's Organic Act clients. He cannot simply dump them or desert them. As a lawyer, he is absolutely subject to the Guam Rules of Professional Conduct. And as a lawyer for these 22 agencies, he owes them undivided cornerstone ethical duties of competence, communication, diligence, loyalty, and confidentiality, all of which he has unlawfully and unethically withheld from his agency clients. The AG's actions violate the Organic Act of Guam, the laws of Guam, and the Guam Rules of Professional Conduct. The Attorney General's responsibilities are conferred by different statutes and laws. But the Attorney General, according to the Organic Act of Guam, is the government's lawyer first. The sources of law that confer the Attorney General's powers and responsibilities include the Organic Act, the laws of Guam, and the common law. The Organic Act provides simply that the Attorney General shall be the Chief Legal Officer of the government of Guam. The government, in turn, according to the Organic Act, consists of the 3 branches: executive, judicial, and legislative. In other jurisdictions, the Attorney General is a Chief Legal Officer of the state. On Guam, it's different. He's not the Chief Legal Officer of the territory. He doesn't have the common law powers that are accorded to those Attorney Generals of those other states. He has the common law powers associated with his duties under the Organic Act as a Chief Legal Officer of the government of Guam.
So when I read the Attorney General's brief, I don't think there is a dispute that the professional rules, Guam Rules of Professional Conduct apply, but he says that they apply subject to the provisions in the Organic Act and the laws of Guam. It's I guess it's a different tiering: Organic Act, laws of Guam, Guam Rules of Professional Conduct. So in my mind, what are the provisions, if any, of the Organic Act or Guam statutes that may modify, like you've mentioned, duty of confidentiality, attorney-client privilege, conflict of interest? Is there anything specified in the Organic Act that would modify the rules, the duties under the rules of professional responsibility.
Your Honors, just to be more
Hang on
precise.
1 second, Ms. Travis, before you answer that question, I just want to make sure we don't have technical difficulties. It looked like we had a glitch. We're still recording. Everything's fine. I know that we're off on our YouTube channel, at least up here, but you may proceed.
Thank you, Your Honor. Justice Carbolito, to be more precise, what the Attorney General is actually saying in his brief is that his dual cognizance over prosecution providing legal services cannot be defeated by ethical restrictions. He says that the separation of powers doctrine requires the ethical rules applicable to his duties conform to the structure of government mandated by Congress and the legislature.
But you don't have any disagreement that the Attorney General can provide these dual roles as prosecutor and provide legal services to the agencies of the government.
Generally not, Your Honor. I don't generally have a quarrel with that. In the vast majority of cases, the conflict of interest isn't even implicated. However, the Attorney General has self-inflicted a conflict in this case, and he has set the tone actually for his entire administration in the past couple of years. However, there's no dispute that the Organic Act vests in this court control over attorney conduct and the ethics of attorneys. That is a specific power that is granted to this court. And I would submit to Your Honors,
You can continue, Ms. Travis.
consistent with the Organic Act, this court, the rules of professional conduct are actually supersede any possible Guam law that may be to the contrary of that. So in terms of prioritization, Your Honor, I think that the Attorney General quibbling about whether or not he owes certain duties to agencies, including, for example, loyalty, he disputes that. He states that his loyalty is to the amorphous people of Guam and not to agencies. That cannot be, Your Honor, because that violates, that's part and parcel of what makes a lawyer. You owe loyalty to your clients.
Do you suggest that the attorney, it was unclear to me whether you were asserting that because the Organic Act role of the Attorney General as the chief legal officer, that has to take precedence over his role as a public prosecutor, and he can't elevate his statutory public prosecutor role above his constitutional role as the chief legal officer. But both of those duties appear to be mandatory.
That's correct, Your Honor. However, I guess really the issue here is what happens when a screen is implemented. Which side of the screen does he sit on? His role under the Organic Act is as the agency's lawyer. So to the extent that there's a conflict, a screen must be implemented, he can't violate his duties that he owes to the government of Guam.
So if you were the Attorney General and you had the duty to prosecute criminal laws and advice into civil litigation agencies, how would you go about proceeding in reference to advising for example, Director of Administration in the event that there was some uncovering of wrongdoing? How would you administer the various under that scenario?
Your Honor, it's the same as any other client, actually. To the extent that it's past wrongdoing and you're not using the advice of counsel